What up? What up? Freedom of speech and press. We're going to go over press too. Uh, Another part of the First Amendment that is a hallmark of our democracy. You know, we've talked about earlier petition and assembly. Those are not, well, I guess assembly you see a lot, but petition you don't see so much. It's not so in your face. But speech, there are thousands of cases that the courts have made rulings on in regards to what exactly are your freedoms when it comes to this provision of the First Amendment. Again, it's one of the most referenced portions of the Bill of Rights in the Constitution, and definitely one that is really protection of your rights in a democracy, especially when you're critical of the government. I'm going to go quickly through the first part because I got through, I think, every class period, at least prior restraint. But again, there are tests used by the court to determine if speech is protected. And the first one was a bad tendency doctrine established in Gitlow v. New York. Again, this is the first case that starts the process, and we'll add selective. Hopefully we don't have a little tabbage problem. Starts the selective incorporation process. The 14th Amendment allows for this, but it is the first case that takes a portion of a small select part of the Constitution and applies it to the states. And in this case, it's speech, and it says that you do have a right to speech, but government entities can ban or prohibit that speech if there is a tendency of that speech being bad. And I use the example of racially abusive speech on college campuses. Generally speaking, this is not deemed to be a violation of your rights if we restrict that. Your rights to the First Amendment are further, I don't know what word I want to use, refined or sharpened with the Schenck case. Schenck versus the United States, which kind of takes a very vague concept as a tendency to be bad and makes it a little more clear. And what it says is the government can restrict your speech if there is a clear and present danger from that speech. Again, not overly clear, but a little more clear than the Gitlow case. Prior restraint means you cannot restrict speech prior to it being spoken or restrict press prior to it being printed. Individuals can be punished for lying or for defaming someone, but you can't do it until after the speech has been spoken or written. So defamation means you're lying about someone else and they have suffered some harm from it. Slander is speech. Libel is written or press. And I don't know if that's in the notes, but those two terms you should know. Slander is a spoken lie. SS, slander, spoken, speech. And libel is printed or written lies. You are not protected. You can't say, well, I have free speech. For those who think the courts have ruled that lying is not protected by the First Amendment speech clause. Again, I said today, political speech is the most protected speech out of all speech. So if you can make whatever your speech is or whatever you're talking about political in nature, or if it revolves around a political issue, then it's likely the court is going to rule for your side. Definitely protected more so than any other aspect of speech out there. Fighting words, however, are not protected by the First Amendment. The court has ruled. Speech that leads to violence, that leads to bad things happening is not protected and can be restricted. So you can't say I'm going to kill somebody and say, well, I've got a First Amendment right to speech. That doesn't fly. Symbolic speech, there's been several cases dealing with this, and generally it is protected, certainly if it's a political aspect. So when you talk about Texas v. Johnson, you're talking about a court case that dealt with the burning of, oh no, I guess that's not bold. You're talking about a court case that deals with burning of the American flag. And if it's your own flag and you burn it in public to protest the government in this case, then it is protected speech. Tinker versus Des Moines is important to all of you guys because it is the first case that establishes that students have rights to free speech in a school, not nearly as expansive rights as you do in the general public, but in school you do have some rights. What the case ultimately also said was if a school district finds whatever the student's speech is to be disruptive, it can be prohibited. So, although this says that kids do not lose the right to speech when they enter the schoolhouse gates, um, if it's deemed to be disruptive, it can be restricted. And schools have used the precedent set in Tinker v. Des Moines to limit speech in a variety of fashions in the school atmosphere. Press deals with obviously written. Generally speaking, you're talking about something that the public in general can see. And freedom of press is, again, another hallmark of our society. The press, as you know, we've talked about the media, oftentimes being the watchdog of the government, oftentimes setting the agenda. So when you talk about their ability to do this, you oftentimes talk about their ability to do this without fears of retribution from government officials. Right of access. This is very interesting. You'll see this mostly at the local level. Is Freedom of Information Act was passed in the 1960s to provide access to public government files. So you can file a Freedom of Information Act for a variety of things, whether it be what the school district is spending money on, what the city is spending money on, what the federal government is, spending money on. A lot of times it has to deal with money and how we're using taxpayer dollars. But there's a variety of things or a variety of issues that may come about when someone files a Freedom of Information Act proposal. And what this means is you're critical of the government for something that they have done, and you want all the documents that are attached to that particular action. And there are provisions in this Freedom of Information Act that say that certain documents should not be released. But it does provide for usually the press, but individual citizens as well, access to government files. This was initially passed to address the executive branch in our federal government, but it has more action at the local level practically today. Executive privilege, the idea to withhold information from the courts. U.S. versus Nixon is a court case that deals with the president trying to withhold all of the information that he had, President Nixon, in regards to the Watergate scandal. What the court ruled in this case is executive privilege is a right that the president has, but it is not inclusive of every interaction that the president has. And in this case, the president was facing criminal charges. So what they ruled in this particular case is it did not apply in criminal proceedings. Shield laws, think of it just like that. It's a shield. What these laws generally do is protect the press. If the press has some information that is provided them by a source about a government official, a government entity, etc., they do not have to reveal who that source is. If you did not have these pieces of legislation in effect, you might have people very, very unwilling to reveal information they have about wrongdoing in government entities. So, for example, you may have information that says that the Elmhurst police are racist and pulling individuals over simply because of their race, and that the chief of police, this is all hypothetical, this does not occur in Elmhurst, has directed his police officers to do so. You want to reveal that, so you give it to the press, all the information that you have. The police are angry about this, and they try to get the source of the information. Who provided this information? Generally speaking, that information is not revealed in any regard. So as a media outlet, usually the newspaper, news on television, you have some protections as a reporter to not reveal who your sources are, which leads individuals who know of wrongdoing to be much more likely to approach the media to reveal whatever the wrongdoing is. I think I mentioned this in freedom of speech earlier. But defamation is not protected. There is a distinction between libel, which is written lies, and slander, which are spoken lies, not protected. Obscenity, generally speaking, the court has ruled that obscenity is not protected by the First Amendment. However, the case Miller versus California, which deals with porn, um, they set up another test to determine whether or not a restriction of obscene materials, nudity, etc., uh, is okay, is constitutional. I'm eliminating this because it's such a complicated case and people are always asking about it. Like, what is that? Miller versus California, the most important aspect of this is A, they said that obscenity is not protected speech, but B, they said that it was up to each community to determine what was obscene. So there's this community standard. So what is obscene in one community may be different than another. You may have one community that allows for strip clubs and another community that does not. Obviously, we know that Elmhurst is a wholesome community and we don't allow for those things. But obscenity in regards to printed obscenity, pornography, is determined at a local basis. So I think the court in this case allowed for some flexibility in regards to determining what is obscene and what is not obscene. Certainly, the federal government sets standards for the internet, since it crosses state lines. The federal government determines what is obscene and what isn't. Student press, Hazelwood versus Kohlmeyer, restricts your ability to write whatever you want in the school newspaper because, and this is how they ruled, because it is a school sponsored, in our case, a class, that you did not have the same rights that you did if you were working outside of the school. So again, your rights, which are proven through all these school cases, are less in a school setting. Outside of school, it's a very gray area, what you do on the internet, etc. There's not a lot of Supreme Court cases dealing with students and what they can do on Facebook, what they can post on blogs, etc., many times being critical of the school district. Regulation of public airways are done by the FCC, again, a federal regulatory agency, and they make specific rulings about what is okay and what is not okay to say on radio, public radio, and public TV. So we're not talking about cable channels. And they set very strict guidelines. It's up to the courts to determine whether they've gone too far. And that be it. Peace.